Good morning, everyone. Can everybody hear me? Can we get a nod of yes? Hello, Annette?
Yes.
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 Have Celeste Favor and Mr. John DeRoth. Thank you. Good morning. Thank you for joining us this morning. We are zooming in today here from Fairfax Realty Premier on the do's and don'ts on rentals. So John will be doing the legal end portion of this. John, can you hear us? Yes?
Yes.
John, okay, great. You're there. Okay, perfect. Just want to make sure everybody can hear me. All right, perfect. So let's start with rentals right now. So of the ones who are here, Annette, or is it Celeste? I see Celeste. Are you guys doing rentals or have you done any recently? Hello?
Yeah, I just sold a rental though.
Okay. And were you on the listing side or did you represent the tenant?
Listing.
Listing. And how did that go? How did that go for you?
It was great.
It was good. Okay. Well, it's a good starting point, especially when you're, I mean, it's not a sale per se, but that tenant or listing, I mean, certainly you're going to stay in touch with them because what's a tenant going to do eventually? What's a tenant going to do a year or 2 years from now? Hopefully.
Yeah, hopefully buy something. be a
Exactly.
buyer.
Good, good. So you certainly want to stay in touch with them, and it's a good way of starting and getting some business under your belts, of course. All right. So with rentals, I just want to just point a few things out that I've noticed, and I'm not saying you have done this, or if by any chance you've seen or come across someone who potentially might have been doing a few of the violations that we want to make sure you all are not engaging on doing. So when you're listing a property for rent, please understand that you are not able to market these properties, even if it says coming soon. You've got to wait for that to go active. I know some agents like to sort of get the upper hand or sort of are anxious to making sure we get these things rented sooner than later. But at the end of the day, you have to stick to what the contract says. And the law is, yes, you can put a coming soon status on a rental, but you are not able to market that yet. Okay, so please keep that in mind. That does also include pictures, texting, social medias, Facebook, Twitter, Instagram, none of the sort. You cannot do any of those until the house is actually active on Bright. Okay, so just want to make sure that's clear. All right. As far as advertising the property itself, I know some agents tend to, well, how do I say? If you're not going to take a picture for yourself or you feel that you're not that great photographer, if you go on the internet, I'm pretty sure you're going to find a picture of that home, correct? It's going to be there from a previous listing. It can be there from Zillow, any sorts. But at the end of the day, you must take those pictures yourself. Please understand that if you're going to be using stock pictures or pictures from someone else or the previous broker, you need permission to do so. Okay. And I would urge you, if you are certainly representing your clients, please do so adequately, which means going the extra mile, making sure you're taking the most current pictures of that home. I've seen homes in the middle of the summer, September, and I'm looking at a picture with snow outside in the front yard. So what does that mean? I'm sure that's not the right picture, correct? It's a picture of the home, but at another point in time, a year ago, 2 years ago, we don't know. But again, you're not giving the adequate representation of what that home is like today. Okay. Any questions so far? Anything I've said that doesn't clear? No. All right. Celeste, are you there? I see you, but I don't. Celeste?
I'm here trying
Okay.
to ask.
Yes, you have a question? I'm sorry.
No,
Okay, okay, good.
I have a question.
Oh, I'm sorry. Yeah, sure. Go ahead, Annette.
So you say you can put it on coming soon, but you can't do any marketing or anything?
That's
Okay.
correct. That's correct. You can't market it yet because it's not an official active listing per se. Think of it that way. Okay. The coming soon status, who's going to see a coming soon status? Between you and I, who's going to see a coming soon status? Who's the only one? Agents, other agents, correct. And they're going to contact you. And they're going to contact you. Hey, listen, I see that's coming up. Can we go see it now? Well, not unless you make it active. So if you had to do that, so let's do an example per se. Let's suppose the client tells you, we're signing the rental agreement today and you can put it on coming soon today, take the pictures, advertise it, but you can't show it until Saturday. If that happens, but you, like you said, again, if you put it on coming soon, the only individuals who are going to see this are the agents, correct? And they're going to call you because they've got somebody who wants to get ahead of the curve as sort of not to miss out on this opportunity. Even if you were to reach out to your homeowner and say, listen, I've got somebody who wants to see the property today. I know you told me you don't want to show it and make it active until Saturday, but can I get him in there today? Even if they said yes to you, you can't unless you make that property active. So please keep that in mind. If you are going to do that, or even you for that matter, what if you get a potential call? What if you get a potential client who you know is wishing to rent in that neighborhood for that price range, which meets the needs of what you've just listed? I'm pretty sure you're going to want to run in there and show them the property before Saturday, but you can't. So please keep that in mind. You must actually make it active in order to do so, okay? To make it fair for everyone. That's all. All right. Any other questions? I thought somebody else was going to. No? We're good? All right. And then, of course, providing access and proper access to agents. So when you're getting calls, most of you are using combo locks or central locks, correct? Annette, do you have a combo lock or a central lock? You have central lock? Okay, great. So for combos, just understand this. Don't give out that combo code to just anyone. I've seen it. I've heard it where sometimes agents are either too busy to go or they're just like, you know what? It's Saturday morning. It's raining. Here, look. Here's the code. 1, 2, 3, 4. Help yourself. Go in there and see. And if you like it, let me know. That's a big violation. Please, please do not do that. It's not just for the safety of the home, the homeowner itself, but it is a clear violation. That combo code cannot be given out to just anyone. All right, please keep that in mind also. All right, so listen, there's other ways of getting in trouble, and I certainly can enumerate a number of them, but right now this is why we have John DeRoff, our attorney here, and he's going to take it from this point forward and also touch on a few other items. I'm still here, so I will still be zooming in. John, please.
Thank you, Alfredo.
Thank you, sir.
So I'm going to talk a little bit more about rentals and sort of how it relates to fair housing. But so I'm going to sort of start off with fair housing first. Just as a reminder, fair housing basically means you're not allowed to discriminate. And when it comes to fair housing, there is both a federal overlay, a state overlay, and a county overlay. So to begin our discussion, we'll just sort of remember that fair housing comes from the Fair Housing Act, which was part of the Civil Rights Act of 1968. And it was later amended in 1974 and again in 88. But basically that sets the floor for discrimination and what you are not allowed to do. And the protected classes under the federal guidelines are race, color, national origin, religion, sex, familial status, and disability. Now, familial status has to do with families because you're not allowed to discriminate against people with families. The only caveat to that is if you were dealing with a property that's in an age-restricted community like Leisure World, then it's okay because there's a special carve out because only people over 50 or whatever the age is there are allowed. But then we have Maryland, okay? And Maryland adds on to your protected classes. And so in Maryland, marital status, sexual orientation, and gender identity are protected classes. So you cannot discriminate against those classes under Maryland state law. And finally, under local ordinances, and I will tell you, I know that Montgomery County and Prince George's County are part of it, and there are at least 6 counties. Source of income is a protected class, okay? You're not allowed to discriminate against people based on their sources of income. Other protected classes that you may find at the county level include age, ancestry, creed, ethnic origin, family responsibility, lawful income, occupation, personal appearance, presence of children, and again, we talked about source of income. So when you are working on your listings, as you're thinking about advertising, and also while you're thinking about vetting your possible tenants, you need to keep in mind that you are not allowed to discriminate against anyone. And so the question is, when you're evaluating a candidate for your rental, what should you, how can you choose, right? Because you're not allowed to turn anyone away. But what you can do is you can create objective criteria. For example, you can define an acceptable credit score. You can define an acceptable income level. So for example, if you're listing an apartment or a rental, I should say, for say $1,300, and you do the rubric and figure out, okay, you want to make sure that it's only say 30% of someone's income. And so you decide that your minimum income for that apartment is going to be, I don't know, $60,000, $70,000, whatever the case may be, okay? The issue is when you are evaluating possible tenants, you have to have a neutral baseline that everyone follows. So every single applicant for your unit, they all have to have a minimum income that you have figured out that you need, that you think to encourage payment. Because what you're allowed to do is you're allowed to make decisions based on credit worthiness, but you're not allowed to make decisions based on income. So one of the questions that we get quite a bit has to do with vouchers. Okay, do I have to accept vouchers? So the answer is yes, in Montgomery County and Prince George's County. And there are, I believe, 6 counties that do require it. And there was, and I don't know the status of it, but there was a movement in the state legislature, at least in 2020, to make requiring the use of state vouchers a statewide deal. But, you know, a lot of agents I know are working in Montgomery and Prince George's County. So definitely in those counties, it's an issue. So, but again, as long as you have your baseline your baseline qualifications, and also, you know, you may want a rental reference, you know, from maybe a previous landlord, you know, to make sure that, you know, you're dealing with nice people. You know, did they pay on time, you know, those sorts of things, because you are absolutely allowed to assess credit worthiness. Same idea in the mortgage market, not that I'm going to talk too much about it, but the whole issue is, do you think this person is going to pay the rent? Okay. So that's why you can establish uniform criteria, such as a minimum credit score, you know, a minimum income. So, but how the person obtains their income, that is a separate situation. Okay. So, you know, you are not allowed to assess the source of income. You just have to know that it's there, and that someone can potentially pay. So what happens when you run into a problem with fair housing? So, oh, and sorry, so I want to talk a little bit more. So we've talked about sources of income, but there are some other issues in fair housing that will come up when you are looking at, you know, working with clients, or as a lender or as an agent working with someone who is listing a rental property. Okay, because even though we tend to think about these in the areas of home buying, it is equally present in the rental market. The first one is block busting, okay? Encouraging potential renters to look elsewhere because you could be steering them to certain neighborhoods when you shouldn't be. Or if you've designated, let's say you have a multi-family dwelling, maybe you're working with someone who has maybe 4 apartments or something for rent, and you're only designating, say, 1 apartment for families. Well, you can't do that. But what you can do is know the fire code, okay? If the fire code says only 4 people can reside in a property, then only 4 people can reside in a property. So if you have a family of 6 that wants to reside in a property that the fire code says only 4 people can stay in, guess what? It's an objective criteria to say, I'm sorry, this is not a suitable housing arrangement because the fire code won't allow it. Okay. So that's okay. All right. Because then your objection is not based on the fact that there's a family of 6 people. The issue is the property can't accommodate it per the fire code. But you do want to be careful of steering, which is channeling your tenants to particular areas based on, those prohibited factors. You also need to be careful in your advertising, okay? Make sure, just like with a sale, that your advertising is focused on the property. If there's a pool, great amenities, fabulous primary bedroom, whatever the case may be, close to metro. Your advertising needs to continue to be a descriptor. Now, the other thing, because you're dealing with credit worthiness and you are dealing with, if you have a minimum credit score that you're only willing, that your landlord is only willing to, entertain, if you want, I personally wouldn't put this into an ad, but as long as it's applied equally to everyone and say, minimum credit score 650, that's acceptable because that's an issue of credit worthiness. Okay. And you are certainly allowed as a landlord to evaluate credit worthiness. Okay. The other issue that you want to be concerned about is intent and effect. You may not have an intention to discriminate, but certain activities can have that effect. Okay. So you do want to make sure that even if you're not intending to, like, for example, and I'll go back to my family of 6, right? So certainly it's one thing to say, I'm sorry, the fire code has said that only, 4 people can reside in this property, therefore that's not going to work, versus, oh, gee, this is just not a suitable unit for a family of your size. Okay. And you're sort of giving the impression that you just don't want a large family there. So for example, if let's say, a family of 4 came to look at your unit and you said, this is not a good property for a family. A better property for a family is, there's better schools over, wherever. That you cannot do. Okay. Because now you're steering. And even though you have the best of intentions trying to put your client first, if you're representing the tenant, you are potentially in a landmine. Okay. Because you're trying to be helpful, but sometimes being helpful breaks the law. And so that's where you want to just make sure that if your client says, I want an apartment for about, $1,500 a month, I want to live in Bowie, I want, whatever amenities they're looking for, you as the agent, that's what you should be trying to find them. Okay. Based on the criteria that they're giving you. Now, certainly it's okay as a good agent to say, well, I know that you said you wanted Bowie, but, and maybe Crofton is nearby, and you say, you know what, based on your criteria, even though it's not Bowie, I found some great stuff in Crofton in your price range. that's okay too, to make those kinds of suggestions. But what you want to do is you want to make sure that you are, or maybe, something that's maybe 5 minutes from Bowie, something that's close is what I'm basically getting at, because certainly you may want to make a suggestion to say, gee, if you're having trouble finding whatever you wanted in a particular location, to say, well, have you thought about expanding your search? Are there other places that you'd like to look at? And sort of keep it open-ended and keep control with your client so that you're not falling into a trap of potential steering. Just say, gee, we're having a tough time. Are there other areas you'd like to consider? And if they ask you based on your knowledge, you can say, well, this city is this, that city is that, why don't we go take a look? I think that would probably be okay. So as a reminder, the Fair Housing Act and the Maryland counterparts, they are administered at the federal level by the Office of Fair Housing and Equal Opportunity. In Maryland, it is with the Civil Rights Commission. Okay, so the Commission on Civil Rights is who hears your issues in Maryland. If you violate fair housing, it is very, 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 very expensive. Okay. Under the federal scheme, if you are caught violating the Fair Housing Act, your first offense, the fine is up to $19,987. If you have a second offense within 5 years of your first offense, the fine goes up to $49,467. If you have further violations within 7 years of that first offense, your fines go up to $98,935. Now, in Maryland, if you're caught violating the act in Maryland, I believe the fines for the first offense is $5,000. The fine is also for a second offense is around $15,000, and the fine for a third offense is $25,000. Now, the other thing to keep in mind is that a violation of fair housing laws in Maryland is also a violation of the Brokers Act. And that's where you can start seeing some criminal charges when you start violating the Brokers Act. So what happens is when you start down this road of fair housing, it can very quickly escalate to some very serious penalties. And so you want to make sure that you're doing your best to avoid these pitfalls. And there are actually some very good resources out there that can help you do this. So one resource is your broker, Anna, Jerry, and Alfredo. They are an excellent source of help. Another source is me. But if we're not around, I wanted to review some landlord-tenant items with you. Oops, hold on, I have to get to them again. Oh, I know what I want to do. I'm going to share my screen. So the first one, even though this is in Montgomery County, it's a very good guide. Let's see. Where is the screen that I want? Let's see. Is this
Hey, John, while you're looking at that, I just wanted to mention real quickly of all of these potential violations that agents may potentially come across, just to remind them that their E&O insurance does not protect them when these issues come up. So please keep aware of that as well. Okay.
Okay. That is very good to remember. Let's see. So are you able to see, because I'm pulling up, so this is from Prince George's County. Are you able to see this, or is this a wrong? Are you able to see this green form that says landlord tenant?
No, we're just seeing termination of tenancy and landlord breach of lease.
Okay, that's in a separate tab. All right.
Yeah.
Let me move this to a new let me move the stuff that I want to do so that way you can actually see what I'm talking about. Just give me 1 second. Because I thought you'd be able to see it, but then you can't. All right. There it is. Okay. I got one more resource I'm going to pull over for you, and then this will work correctly. Like, there we go. All right, so now we're going to go back to share screen and we will share the correct screen. All right, let's try this again, shall we? All right, so the first one I wanted to share with you is this. Now you should all be able to see the landlord tenant sheet from Prince George's County. So this is reviewing, this is giving you some helpful information for Prince George's County. You see that in the first column, it's the Maryland Code and Rules. This is showing you some additional resources for Prince George's County. If you go to this website, princegeorgescounty.org with the, for this PDF actually, the links are all live so that you can go to different places to review. So if you have some questions about what is appropriate in Prince George's County, this is a very good place to start. Okay. But this is a landlord tenant handbook. So are you able to see the landlord tenant handbook? Or do I need to, here, let me reshare the screen for a second. That way I know you're looking at the right thing. Okay. So this is the landlord tenant handbook from Montgomery County. I actually really like this handbook because although this is keyed for Montgomery County, this has some very helpful information that is applicable throughout the state. Okay. This goes and explains, whoops, and this is available online, so you don't have to go anywhere for it. But this talks about the relationship basics for landlord tenant. It talks about licensing requirements. And also I will tell you, if you are representing a landlord, please make sure that your unit is properly licensed with the county. You will want to understand that. It talks about lease provisions. It talks about notices. It talks about terminating the lease, when you can do it, court actions, how to file complaints. Okay, this is an excellent, excellent resource. And so, and it talks about rent escrows and frequently asked questions. And so, you know, obviously we spent some time talking about fair housing, but the other part to this that I get a lot of questions about is, how do I terminate a lease, or I need to go to court, or, you know, all of these things. And so there are items in here that can help you. Okay, but the one thing that I do want to let everyone know, because there was a change in the law, that if you have a month-to-month lease, okay, then 60 days notice is now required under the law to terminate that lease. Okay, and the way a lot of leases are written, so for example, if you are in Montgomery County, you must offer a lease for a minimum term of 2 years, because that's a county ordinance. Okay, so at the end of that 2-year term, you can automatically have your lease renew for a period of 1 month. Okay, as long as it's written into the lease properly. Okay, so let's say you've entered into your lease, 2 years has come and gone. You are now in a month-to-month situation. Either side has 60 days to terminate that lease. Okay. So that's important because, if you are representing the landlord and you want to have someone leave for whatever reason, the first thing I would always tell you is, get a copy of the current lease and go find your lawyer. And the reason is because so many people ask me, oh, I'm having a problem with a tenant, the tenant's not paying, what have you. What can I do? And the first place you have to go is look at your lease. Okay. But also in the context of home buying, where you have a landlord that now wants to sell their home, the question is, what do we do about the tenant? And the answer is, if you're in a month-to-month situation and you want to terminate the lease, you can, but you have to provide a 60-day notice. If you are in the middle of a lease, then the lease will have to transfer to the new owner, unless the lease gets broken. And certainly there are ways to do that.
Hey, John, if I may interject just for a minute.
Yep.
Speaking of, in addition to providing notice, the type of notice that is also provided within that 60 days is also crucial, which has to be in writing. And I always say, if you're representing the landlord, then they should also make sure that they're sending this in writing and certified mail so that they have proof of delivery, so that there's no question when that time comes up. Because I've seen a lot of other landlords, sometimes they'll just give a quick call, a quick text or an email, and then you really have nothing to fall back on. I'm pretty sure it'd be best just to put this in writing and making sure it's delivered.
Yes, I always say that lawyers keep the post office in business. There is no substitute for a good certified letter. The other thing that you actually can do with the mail is you can, if you don't do it certified, you can actually get a mailing receipt. It costs about $1. You have to get it at the window for proof that you sent the notice. So you can also do that as well. The other thing that you need to remember, because sometimes people come to me and they say, well, we have an oral lease. Well, guess what? An oral lease for any period under a year is okay, although I would tell you it's not advisable, because if something goes wrong, you have no piece of paper memorializing what the deal actually was. But for any lease that exceeds a year, it must be in writing. And for any lease, and now I'm going to get in trouble, I believe it is for 7 years or more, can be recorded in the land records. Okay. So what you don't need, however, is if you had an original lease, a written down lease, say for a year, and you also have that automatic extension for the month to month, you don't have to re-execute a new lease. You are continuing to work under the current lease. Now, if you had a rent increase, you may want to memorialize that with an addendum or a memo or something, so that way, everyone's on the same page. But also keep in mind, there are rules in Maryland regarding rent increases. There is only so much that you can increase rent, okay, per year. And so I would advise you to look at the then current statutes to figure that out. I think if I look here in this Montgomery County thing, it will tell me.
You're correct to say that you must give notice, but also I believe in PG County or Montgomery County, it's up to 60 to 90 days notice of the increase in rent. And then when it comes to the actual amounts, yes, there is a certain amount that you can go up by, but as you know, today landlords are basically increasing the rents yearly because of the shortage in rents. And this is where I've seen a lot of tenants, unfortunately, not able to keep up or accepting the new increase and not knowing what their rights are. So I know there's a set guidelines that comes out on a yearly basis. I know in DC, they get posted. Do you see here in Maryland where they do that as well?
So it's going to be posted usually with the local departments of housing is where I think it's going to be. But in here, let's see, I just had my hand, here we go. Notice of rent increase. So here in this Montgomery County document that I'm showing you, on page here, if I just have to move this so I can see it. On page, I just had it in my hand. Notice it, here we go,
Page 20.
See if I can get there quickly. Almost. So that's why I said, even though this document is Montgomery County, it's actually really good everywhere. So this explains how you do the notice of rent increase, okay? And you were right, Alfredo, at least in Montgomery County, it has to be 90 days prior to the effective date of the rent increase. So if you're planning to do it on the anniversary of the, lease, you need to, 90 days out, you have to deal with that. You can only do one increase in a 12-month period. The notice has to correspond with a payment cycle. It has to be in writing. And at least in Montgomery County, there is a model rent increase notice that is available on their website. And in Montgomery County, that's DHCA. So, but, it's the same thing with a notice to quit and vacate. You have to be specific. And this explains, what the notice needs to contain. So that's, the take home here is it's so easy to get into trouble. And yet there are so many resources out there to help you that you really, instead of taking matters into your own hands, look for the resources that are available to you so that you won't get into trouble. Okay. So that's what I would say. And one last resource that actually I wanted to share is from the Attorney General's office. So this is a nice, landlord and tenant tips on avoiding disputes. And this goes through, application fees, leases, rent receipts, security deposits, all of this stuff. And it has some nice scenarios to help you through what you're doing. Okay. So for example, if you are a landlord and you have an application fee and your application fee is more than $25, the landlord can only keep $25 or less. If your application fee is more, okay, and you have a renter that wants a refund on their application fee, you would need to account for any amount over $25. So if you were vetting your property on Rent Spree, right, Alfredo? That's the service that you use?
Right. Rent Spree is $35. The good thing is with Rent Spree, when applicants do apply for a specific property, the good thing is that Rent Spree allows for those tenants who are not the chosen ones to then get that $35 credit back again when reapplying for a new property for the next 30 days so that they don't have to pay it again and again. So that's the added benefit with Rent Spree versus the normal way where brokers are now handling or are still handling, per se, the verification of credit and employment. Then I've seen them as low as $25, as high as $50. But as you said, again, the applicants the broker can only charge up to $25, correct?
Well, no, you can charge more, but if there's a refund involved, you have to either account or provide a refund for the additional.
Correct.
So in the case of, say, using Rent Spree, if say our processing fee here at Fairfax Realty is $25 plus the amount for Rent Spree, and you have your client pay Rent Spree directly, which I believe is how it's done here.
Yes,
So then the total application fee is what, about $90 between the two aspects. And so that way the $25 to Fairfax Realty, I guess, would be non-refundable. And Rent Spree has their own thing.
right, but we don't charge that. All applicants go through Rent Spree and they only pay Rent Spree, period. We, the broker,
Okay, so there's no fee for Fairfax.
No.
Okay. Thank you. I actually did not know that.
That's okay.
So see, we're all learning today. So, but like I said, so I would tell you that if you are in this landlord tenant space, the take homes that I would give you for today are if you violate fair housing, you are violating federal law, state law, county law. You are also violating the Brokers Act. And by the way, you're also violating the Code of Ethics, which I failed to mention before. But if you break a law such as the Brokers Act, that's also a violation of the ethics codes. So there's a real domino effect when you're dealing with fair housing. And it's very, very serious. It's very, very expensive. And many of the fines are civil, but there are some aspects that end up in criminal litigation. So if you are not a fan of, silver bracelets and bars, I would advise you to be careful. But the good news is you have a robust team that is able to help you, because not only do you have some of the resources that I suggested that are out there, there are more. And like I said, personally, I really like the Montgomery County Handbook. It's very, very helpful, even though it's keyed to Montgomery County and there are certain peccadillos for Montgomery County. I actually think it's very helpful when you practice in other places, that there are some good lessons that can be used in other jurisdictions. So that's a good base. Obviously, the Attorney General's website, and also that fact sheet for Prince George's County. But although those are, the selected materials that I chose, every county has their own Department of Housing. And so if you are in Charles County or where have you, and although this presentation is focused much more on Maryland, don't forget in DC, it is a whole other can of worms, but fair housing still applies. And if you have questions about, tenancy and all that stuff in DC, that's like a whole other class. Just because DHCD and TOPA and all kinds of things. But what I would encourage you, and I've said this before, I said this during our last discussion, you have to know where you're practicing, okay? Just because you practice in Maryland, not all places in Maryland are equal, okay? So if you are doing, if you're in Baltimore City or Baltimore County, the rules could be different between the two. I can tell you in Baltimore City, housing vouchers, Section 8, you are required, as a landlord, you're required to accept those, because again, that falls under that whole source of income discrimination. Now, there are certainly other issues with Section 8 because homes have to be approved by the housing authority and all of that. And if you have questions about how that works, I would encourage you to contact, because I don't know the ins and outs of how properties get approved. So I would encourage you to contact the individual housing authorities, or if you have questions or additional research, we can always talk about that offline. But the take home is that, you want to be careful about how you're advertising property and vetting tenants, but also on the other side, when you're showing tenants properties, you need to be careful that you are not steering them into certain places, because that's still not allowed either. Okay. And so just remember, you have to have objective criteria when you are evaluating tenants. So really evaluating credit worthiness is a good one. And if you know that, a certain unit can only accommodate X number of people, based on the fire code, like, say, for example, a 2-bedroom condominium, maybe it can only take 6 people. Or it is also okay for a landlord to say, I only want 4 people living in my house, because they just figure, even if the house has 7 bedrooms, because maybe they figure there's more chance of breakage or damage, or who knows, right? you are allowed to objectively say, I don't want more than 4 people living in my house. That you're allowed to say. Okay. Because then if you had, you know, a group of 4 roommates who wanted to share, or a group of 6 roommates who wanted to share, they're off the table, just like a family of 6 is off the table. Because the issue is you have to apply it to everybody the same way. So you are allowed to place limits on your house. You were allowed to say, I don't want more than, you know, more than 3 people living there, because otherwise I just think, you know, there's going to be too much damage, whatever the case may be. But it has to be objective, quantifiable, objective and quantifiable. Okay. So if you want to set, you know, credit scores, if you want to set numbers of people to occupy, that's okay. If you want to rely on the fire code, that's okay. But the idea is that it all has to be objective. Okay. And those are the ways that you are going to stay safe on your fair housing, as well as if you are advertising just relying on the characteristics of the property. Do not rely on the characteristics of who you're looking to rent to. Okay. It's all about the property. It's not about the people.
John, thank you so much. That's very helpful. I just want to touch on a few things that you had mentioned previously, just to make sure we're all still on the same page. Landlords, please understand, if you're representing a landlord to list a property in Montgomery County or even in PG, there's a rental license requirement for the landlords to have. So please make sure that they are applying for it, or they are in the process of applying prior to the tenancy commencing. It will then cover that landlord and that tenant in the event of any litigations that may arise during or after the tenancy is in place. So please remember, in Montgomery County and in PG County, and I'm pretty sure in other jurisdictions, you may be required also to have that. I believe the fee is about $110, if I'm not mistaken, per year. It's very minimal, but it certainly does do what it needs to do, which is cover that landlord in the state of Maryland. Okay. Another thing you had mentioned, John, I just want to make sure I'm clear. You said in regards to the indications of the minimum requirements that a landlord would want, let's say 650, 700 credit scores. Can they also say to the fact that they would want someone renting, let's say $2,000 home to have a minimum income of $60,000? Could they say that on the listing?
So here's the thing. That's probably not something I would advertise, but that's something that I might use to evaluate applicants, but that's just me.
I've seen them, so I'm just curious.
So, I mean, it's okay to do, because you're basically telling prospective people, if you don't make this much money, you're not going to live here. But the downside of that is, let's say you make that statement in your advertisement, right? And then someone comes along and I don't know, they make a really good impression. And maybe you said you have to make $60,000 and here's someone who makes $58,000. Okay. Well, now you need to reject that person who makes $58,000, even though, well, what's $2,000, right? Now you have to reject that person because you have made a bold statement that says, if you don't make $60,000, you're not living here. Because if you then take someone who makes less, then you have to figure out why, if someone else who made 55,000 or 58,000, but you decided to reject them, why you did that.
I see
Now,
where
you could certainly make a statement of, well, the person with 58,000 had a credit score of 675, but the person with 60,000 had a credit score of 530. I mean, you could do that, but the issue is these are indicia of credit worthiness. And so I would tell you, you know, to the extent that what you want to do is you may want to have an evaluation rubric that you're not advertising, but whatever your rubric is, if someone accuses you of fair housing, you want to make sure that your practice is down and that you have followed the same procedure for everybody.
very good.
That's what I would tell you.
Okay. Excellent. Thank you. Thank you so much, John.
There is one last, sorry, Alfred, there's
yes,
one
no,
last
go
thing I
ahead,
did want to touch on. That's E&O insurance. I just want to make sure that everybody understands your E&O insurance, your errors and omissions, does not cover you when you break the law. Okay. So if you break the law and you try to get errors and omissions coverage, your insurer is going to say, I'm so sorry, we don't cover violations of law. So, so if you violate the law, even if it's a mistake or an honest mistake, just know that that's a problem. And so I'll also put in a word for the guarantee fund, okay? Because just remember, if as a result of your actions, there results a loss and the guarantee fund has to pay out if it goes that far, just remember your license will be automatically suspended and you will not be eligible for reinstatement until you repay the guarantee fund, plus I think it's 12.5% interest, plus whatever fines and anything else that you have to do. So the penalties for violations are very, very severe. And there's no insurance for it.
Listen, at the end of the day, I hope we didn't scare you guys, but we're just basically just trying to make sure that it is clear as to what we can and cannot do out there, especially working with rentals. We can certainly get into trouble very easily, believe it or not. I'm sorry, yes, Annette.
Are there any negatives to not having a license, rental license?
I'm sorry, say that again.
Are there any negatives to not having a rental license?
It's a
Yes.
requirement by law.
Well,
Landlord to
but
have.
in addition, if you don't have a rental license and you are renting, the courthouse doors will be closed to you. You cannot sue for back rent. And any of those other protections that you might want to avail yourself of within the court system as a landlord, if you have a problematic tenant, will be closed to you.
Yeah, you can't file a claim against the tenant in that matter, because the very first question is when they go in and you try to put in a request for either to vacate or because of some ordinance that they're not following, or they did not adhere to the actual contract lease term, then when you, the landlord, go and file that complaint at the courthouse, the very first thing is, do you have a rental license? When did you obtain it? What the number is? And they're going to pull it right there and then. If you don't have it, you can't file. So it would be to their advantage to do so. Okay. The resources that John had in regards to the tenant and landlord affairs, it is available online. I will send out the link in case you guys want to download that or just have it available. It is part of the requirements when working with tenants as well, that you have to supply them with a copy of it, or at least the link for them to see the tenant landlord handbook in the jurisdiction that they're in. And please make sure you're not crossing your forms. I've seen where tenants, agents working in Montgomery County are using PG County forms and vice versa. So please make sure you're not crossing over the forms in the jurisdictions that do not apply, okay? Because at the end of the day, you need to service your client and in the state and in the county in which that home is in, okay? John, thank you very much for all the insight that you have. Are there any questions that you may have here at this time? Anyone?
John,
Yes.
this is Hutch.
How you doing?
Okay, I have a statement to make here, and this was raised by you. For instance, I have seen it in many listings where the landlord is saying that he wants a minimum, say, of $60,000 a year in income. And to me, that doesn't seem to make sense all the time, because someone can be making $60,000 a year and say that person has, say, $3,000-4,000 a month in debt. Whereas a person making, say, another person making, say, $58,000 a year has debts of more or less zero or very little. So that is why anytime I see that statement, I sort of have an issue with.
Well, and that's why I would actually counsel you not to put that information in your advertising.
Right.
Because if you're going to, then I would tell you that you are drawing a hard line that says, only that income. And that's why, when you are measuring credit worthiness, you should create a rubric that, I'm willing to accept someone between, say, $55,000 and $65,000. I'm looking for a credit score between this and this. And you can also say that you're looking to make sure that the debt ratio is not more than, say, 30 or 40%, because that's really,
Exactly.
when you're applying for a mortgage,
Right,
that's what your lender is doing. So as a
Yeah.
landlord, you're essentially doing what a lender is doing.
right,
Because
right.
under the housing guidelines, 30% is kind of like that sweet spot. And it's always based on gross income, not net, just so you know.
Right,
And so that's why, I would certainly shy away from advertising a minimum income
right.
in your advertising, just because you may want to have flexibility to figure out your debt ratios.
Exactly. Rent to income. I mean, debt to income ratio. Right. I also have another question. This is with regard to rent increase in Maryland. I have not seen anywhere where it is said categorically that the landlord cannot raise his rent more than X amount. I have not seen any specific numbers for rent increase. Traditionally, I think I've seen anywhere between 2% and 5%, but I understand in Maryland, the landlord can raise his rent to anything he wants. But of course, it would behoove him not to go beyond a certain amount, but I've never seen a specific rental amount. Have you?
I have. Some of it is in the some of it is
Handbook?
in the time frame. Some of it is under the guise of if you have a home that has Section 8 vouchers, a voucher program. But the other part of it is some counties, and I will have to double check on what the state has to say, but some counties have their own caps.
Okay,
So that's why, Alfredo was talking about, make sure you know which forms you're using. And I always say this, you have to know where you're practicing, because the rules can be different depending where you are.
right, because even in the rental lease, specifically PG, where I do some of my rentals and so on, there is no clause that states categorically what the rent increase is. Mention is made of the rent increase. And I think it said clearly too that no more, the landlord cannot raise that rent more than once in any particular year. But
That's
there's
correct.
no clause in that lease that states what the amount that landlord can increase that rent. It's not stated in PG lease.
So, like I said, I'd have to take a closer look at the statutes to determine. But I do know that there are some caps around, and it could only be for certain types of rentals.
Okay. Well, thank you so much. It has been a very informative session, and every time you come on, I learn. You and Alfredo, I always pick up some little piece of information which guides me in my business.
Well, that's great. Well, Hutch, listen, if you or anyone here now has any questions afterwards, please feel free to reach out to us. The resources I'll be sending out to you as well. And again, we will certainly follow up on, I'll make sure John follows up and see if we can find out what those limits are as far as the increases are. But he is correct to say that it is different in each jurisdiction that you're in. I know DC sends out on a yearly basis the guidelines. Usually they rank between 1% and 3% based on the economic levels and what increases they're foreseeing. But let's see if we can find out for both Montgomery and PG County, just in case that there is some guidelines.
Okay.
Any other questions, guys? Nope. All right. John, again, thank you so much. We will be regrouping again next week. John, you have another session coming up next week, right?
Yeah, so next week is going to be our second coffee talk, which is really just an unstructured session. And if you register ahead of time, we will send you a $5 Starbucks card. And that's really an unstructured time to be interactive. So I really encourage cameras to be on. And if there's, something burning that anyone wants to talk about or having some issues, it's just a time to sort of hang out with me and your brokers, and just, begin reconnecting. So that's really all it's about.
Great.
And these sessions are still on Zoom, right?
Yes, the coffee chat is on Zoom.
I just
Okay.
have a couple of questions for you.
Okay,
Yes.
Hi, my name is Elizabeth. How are you?
good, thanks. How are you doing?
I'm well, thank you. If someone does not pay a rent, how soon can you take them to court?
So if someone is not paying rent, okay, if they have a license, if they're properly licensed, okay, you can take them to court. The process for that is basically you would file a complaint in landlord tenant. It would most likely, the court would most likely see if you can go to, if you could go to mediation to solve your problem. If not, the court will have a hearing. And the other thing I'm going to say is, because I did not talk about eviction at all, so I'm just going to put in a quick little plug about eviction. You cannot evict anyone without a court order. And eviction means no changing locks, no turning off water, no turning off electricity, okay? You cannot touch that house without a court order. So, because if you say turned off the water, there's something called constructive eviction, which is basically evicting someone without throwing them out. And turning off the water or turning off the heat or turning off utilities, that could be considered constructive eviction, and that's a violation of the law. So you're not allowed to do that.
John, regardless of where they are, right?
Yeah, that is
Of the
statewide.
jurisdiction.
That's regardless.
No, I mean, Maryland, Virginia, DC, it's all the same.
Definitely DC and Maryland. I am not familiar with Virginia landlord tenant, and I don't practice there. But if people have questions about Virginia landlord tenant, if you have not met Stephen in our Falls Church office, I am happy to find out from him what the rules are in Virginia.
Okay. And can someone become an owner of your house if they have lived there for a long time and they have a month-to-month lease because their lease already run out?
I'm sorry, Elizabeth, I missed sort of the first part of that question. Someone in the house month to month. So start again, please.
Can someone become owner of your house? Can a renter become an owner of a house if they have lived there for a long time and they have a rent month to month?
No, because they're there with the permission of the owner on the month-to-month lease. So unless, because you're actually asking an adverse possession question, but they cannot adversely possess a home if they have the consent of the owner.
I see. And they are paying.
And the
rent.
lease is the consent.
Okay, so even if it's month to month, even if the lease ended 10 years ago, it does not matter?
As long as they're still operating under that 10-year-old lease on a month-to-month basis, it does not matter.
Okay, thank you so much. Your class was very informative. I really appreciate that.
Thank you.
John, Hutch again.
Yes.
With regard to a follow-up question from the last caller there, in filing a complaint to the courts regarding non-payment of rent,
Mhm.
does the landlord require to have an attorney do it, or can he do it himself? I know
So
in
a land,
DC is very strict with regard to landlord tenant laws, where in DC, you cannot go to court without your attorney.
Well, okay, so here's the deal. If you are an individual, and I understand what you're talking about in DC, so I'll explain to you what the story is there. So the story is that, yes, you can represent yourself. However, if you are an entity, so let's say you formed an LLC to rent out the property, that's where you have a problem. That's when you need to have an attorney representing the entity. That's the issue in DC. In DC, if you as an individual own the property and you are the landlord, you can file, you can go pro se. However, if it is an entity like an LLC that owns the property, you as the sole member of the entity cannot represent the entity, then you have to have an attorney.
Because the reason for my question is I have a friend who had this property in DC and the tenants were not paying any rent, and he went before the court unrepresented, and the judge told him that he should get counsel before he comes back. And
Well-
he tried to say something, and the judge, according to him, told him that should he say one more word, he would be in trouble. He got to have a lawyer. So
Oh,
that's
well, that actually sounds like the judge was trying to save your friend from jail. What that actually sounds like is whatever the issue was in that case, if he had consulted an attorney, the attorney would have told him he couldn't do whatever it is he was trying to do. So it sounds like the judge was trying to be nice to him.
Yeah, because according to him, the judge told him, should he say one more word, he would hold him in contempt of court.
Yeah. So it sounds like in the case of your friend, there was a different problem there. And since the judge can't give legal advice, what he was saying was, you need legal advice. You shouldn't be doing this.
Got it. Mhm.
That was
Okay.
not a requirement for an attorney. That was the judge trying to save him.
Right. It makes sense, surely.
And judges do that because, like domestic law, landlord tenant is one of the areas of law where you see the most pro se litigants. And that's why at least in DC, I think there is, there are places that have free resources to help people because
Right.
it's an area that, it's complicated. The court system is complicated enough, regardless of what your particular problem is that requires court action. So, I would tell you, certainly, if you think that you need to go into court for something, even if you don't want to pay for an attorney consult, even if you don't want them to do the litigation, because what a consult's usually a few $100s or $100 or something, because sometimes you just need to get the legal issue straight.
Right. Mm-hmm.
Or in the case of your friend Hutch, an attorney might have said, no, you can't do that. Don't do this.
Right. Surely. Mm-hmm.
Okay.
Got you.
All right. Anything
So I think
else?
we're gonna wrap it up here. Jerry, do you want to step in here and say anything?
No. I was extremely busy. I apologize. I wanted to be here for this program. I'll watch the video.
Okay, that's fine. Well, I want to say thank you for all of you who were able to participate. As we said again, next Tuesday, we have coffee with our attorney. And then for those of you who've been watching your emails, we also do have the pre-Thanksgiving potluck scheduled for the following Tuesday after that on the 23rd here in our office. So for those of you who wish to join us, please come. If you have any questions, just give us a call. John, thank you again for all of your expertise, your advice. Jerry, thank you for joining us, and all of you as well. And we'll
Thanks
see you next
again.
week. Excellent. Thank you.
Mm-hmm.
Bye.
All right.
Thank
good.
you.
Bye-bye.
Thank you.
Thanks, bye.